A federal judge in Texas just told the FDA they need to pick up the pace, telling them that they have to release a lot more information about the Pfizer vaccine than they wanted to. FDA was saying this was way too much data, way too burdensome for them to disclose this, but a federal court said, nope, get on it. Here is what the order looks like. You can see this is coming out of the United States District Court for the Northern Division of Texas. It's the Public Health and Medical Professionals for Transparency. This is an organization demanding this information. They are the plaintiffs. They are filing this against the FDA, Food and Drug Administration, and they want more data. This case and this order is coming from Mark T. Pittman. You can see this is the district judge. Looks like this. A little bit more about Judge Pittman. He was a former judge of Texas from the Court of Appeals. He was appointed by Donald Trump back in 2019. We can see that Greg Abbott, also the governor of Texas, appointed him to the Court of Appeals before Donald Trump actually appointed him to the federal district court. So he goes from a state level court into a federal level court, has gone to a bunch of schools in Texas, and been around, clerked for a number of judges. He is the person issuing this order. And so he's telling us that this case lands before him and before us as a result of the Freedom of Information Act. This is a FOIA request. This act specifically allows people to get certain data from the government. Specifically at issue is plaintiff's FOIA request seeking, quote, and this is the Medical Professionals for Transparency. What do they want? Quote, they want all data and information for the Pfizer vaccine. Everything that's enumerated under the law, with the exception of the publicly available reports on the VAERS system from the FDA. So there's a database that's publicly available. They don't want that stuff. They only want the stuff that is not publicly available. As has become standard, this judge kind of snarks. He's saying, as is typical here, the parties failed to agree to mutually acceptable production schedules. Instead, they submitted dueling production schedules for this court's consideration. So accordingly, the court held a conference with the parties to determine the appropriate production schedule. Judge Pittman is going to give that to us now, but not before, as we love, quoting James Madison, says, open government is fundamentally an American issue. It is neither a Republican nor a Democrat issue. As James Madison wrote, quote, a popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy, or perhaps both. Knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power which knowledge gives. Judge Pittman writes, John F. Kennedy likewise recognized that, quote, a nation that is afraid to let its people judge the truth and falsehood in open market is a nation that is afraid of its people. And particularly appropriate in this case, John McCain correctly noted that excessive administrative secrecy feeds conspiracy theories and reduces the public's confidence in the government. Saying that a many great leader has said this time and time again. In order for America to govern properly, we got to know what's happening. We have to be able to see it. That's why we talk about accountability and transparency on this channel regularly. So the judge is using those figures as guideposts, and he says, echoing these sentiments, let's go to some case law. He's referencing a Supreme Court case from 1977. He says, echoing these sentiments, the basic purpose of FOIA is to ensure an informed citizenry. This is vital to the functioning of a democratic society. FOIA was therefore enacted to pierce the veil of administrative secrecy, to open agency action to the light of public scrutiny. And Congress has long recognized that information is often only useful if it is timely, and that therefore excessive delay by an agency in its response is often tantamount to denial. If you're going to take 2 decades to give it to us, you might as just, not give it to us. When needed, a court may use its equitable powers to require an agency to process documents according to a court-imposed timeline, referencing a D.C. case from 2014, saying, I have authority to tell you to pick it up. There's precedent here. Here, the court recognizes, writes Judge Pittman, the, quote, unduly burdensome challenges that this FOIA request may present to the government. But, as expressed at the scheduling conference, there may not be a, quote, more important issue at the FDA than the pandemic, the vax, and getting every American vaxxed, making sure that the American public is assured that this was not rushed on behalf of the United States. What else are you doing over there? Stop testing obscure nutraceuticals and focus on what people have in mind. Accordingly, he says, the court concludes that this FOIA request is of paramount public importance. Stale information, he writes, is of little value. This comes from another D.C. Circuit case from 1988. Says the court, agreeing with this truism that if information rots, it's no longer useful, therefore concludes that the expeditious completion of plaintiff's request is not only practicable, but necessary. It is the compelling need for such public understanding that drives the urgency of the request. The public needs it, and they need it quickly. To that end, the court further concludes that the production rate, as detailed below, appropriately balances the need for the unprecedented urgency in processing this request with the FDA's concerns of the burdens of production. We're going to balance this. We need this quickly, but I know it's a lot of work. So here's how we're going to compromise. He says, accordingly, having considered both sides, filing and in support of the applicable law, and the court orders thus. He says, number one, the FDA shall produce the, quote, more than 12,000 pages articulated in its own proposal on or before January 31st. 12,000 pages, they say, we can get that for you. That's due by the end of the month. FDA shall produce the remaining documents at a rate of 55,000 pages every 30 days. First production being due on or before March 1st, until production is complete. To the extent that the FDA asserts any privilege or exemption or exclusion as to any responsive record or any portion thereof, the FDA shall, concurrent with each production required by this order, produce a redacted version of the record, redacting only those portions as to which privilege, exemption, or exclusion is asserted. And the parties shall submit a joint status report on the progress in the rolling production by April 1st, 2022, and every quarter thereafter. So ordered on the 6th day of January, signed by Mark Pittman. Judge Mark Pittman is, of course, telling the FDA, slow is not good enough. Pick up the pace over there. They wanted to just drip this information out over the foreseeable future, basically indefinitely, and that's not good enough. Stale information expires. If they are allowed to do that, nothing useful is going to come out of that information. So the question is, of course, now that the pace has been accelerated, is there anything useful in it? Now that 55,000 pages are coming out every 30 days, now that the court has ordered both sides to prepare a status report every 90 days, and he can get in there and adjust this, maneuver this, and say, nope, release this, release this. If there's too many things that are redacted, he can correct this. He's going to be managing this for the foreseeable future. And we'll see here if there's going to be anything that we can learn from this data, or if it's just going to be a bunch of spreadsheets, or even worse, blanked out redactions. We'll continue to follow it along. I hope you join us on that journey. Subscribe, leave a comment, give us a like before you get on out of here, and I look forward to seeing you on the next one.